There are certain circumstances and conditions where exactly the finality clause or outer clause does not apply. So, those conditions or circumstances are unconstitutionality of the statute. So, exclusion clause does not bar the jurisdiction of the court to try a suit questioning the constitutionality of a statute and action taken thereunder. If the statute which contains the exclusion clause is itself unconstitutional, the bar will not operate. The finality should not be taken to mean that unconstitutional or void laws be enforced without remedy. And the second condition is that ultra vires administrative action. So, the very exclusion clause does not bar the jurisdiction of the court in cases where the action of the authority is ultra vires. If the action is ultra vires, the powers of the administrative authorities, the very exclusion clause does not bar the jurisdiction of the court. The rule is applied not only in the case of substantive ultra-vires but also in the case of procedural ultra-vires. If this authority acts beyond its power or jurisdiction or violates the mandatory procedure prescribed by the statute, the exclusion or finality clause will not be taken as final, and such a clause does not bar the jurisdiction of the court. And the third condition is jurisdictional error. The exclusion or ouster or finality clause does not bar the jurisdiction of the court in case the administrative action is challenged on the ground of the jurisdictional error or lack of jurisdiction. The lack of jurisdiction or jurisdictional error may arise where the authority assumes jurisdiction which never belongs to it or has exceeded its jurisdiction, indicating the matter or has misused or abused its jurisdiction. So, also, the lack of jurisdiction also arises where the authority exercising the jurisdiction is not properly constituted. So, regarding that, there is an important leading case, and that is Suraj Mall versus Municipal Board, Ganganagar, where the municipality collected the taxes for which it was not authorized by the concerned statute. The exclusion clause in the statute was not given effect. The court held that in such a case, the exclusion clause cannot be given effect to bar the jurisdiction of the court. And the fourth condition, that is non-compliance with the provisions of the statute. So the exclusion clause will not bar the jurisdiction of the court if the statutory provisions are not complied with. Thus, if the provisions of the statute are not complied with, the court will have jurisdiction in spite of the exclusion or finality clause or ouster clause. And the fifth condition is that violation of the principle of natural justice, if the order passed by the authority is challenged on the ground of violation of the principle of natural justice, the ouster clause or the exclusion clause in the statute cannot prevent the court from reviewing the order. So, also, final condition is that when finality clause relates to the very question of fact and not of law, so where the finality clause makes the finding of a tribunal final on question of facts, the decision of the tribunal may be reviewed by the court on the question of law. So, these are the conditions or circumstances where the very application of finality clause or ouster clause regarding judicial review is not applicable. And as regarding the very concept of judicial review and its first application by the Indian Supreme Court, in that light, we could mention certain important leading cases such as the Shankari Prasad case, the Sajan Singh case, and I.C. Goloknath case, so also Kesavananda Bharati case, and also the very important leading case, Minerva Mill case, which are the important leading cases beside A.K. Gopalan versus State of Madras, are those leading cases which completely relates to judicial review, and in case of the very Article 32, which empowers the Supreme Court to judicially review all the acts of the legislature and also the executive authorities which infringe or violate the fundamental rights of the citizens, so also the very concept of rule of law, procedure established by law, or due process of law, as in case of United States of America, so also equality before law and equal protection of law, and finally for the infringement and violation of the very principles of natural